When science becomes the last witness. Imagine a courtroom. A man sits in the dock accused of murder. There are no eyewitnesses, no confession. The entire case rests on one thing: evidence examined by a doctor. A bruise pattern, a toxicology report, the angle of a wound. In that moment, science isn't just in the laboratory. Science is speaking in court. And if it speaks incorrectly, if the evidence is contaminated, misread, or manipulated, an innocent person suffers, or a guilty person walks free. This is why forensic medicine carries one of the most serious responsibilities in all of medicine: the responsibility to uphold scientific truth in the service of justice. Welcome to Forensic Alliance of Bangladesh. Today, we examine the critical role forensic medicine plays in maintaining scientific integrity within the justice system, and why, as a future doctor, this knowledge is not optional, it is essential. What is forensic medicine? Defining the field. Before we go deeper, let us establish a clear foundation. Forensic medicine, also called legal medicine or forensic pathology in many contexts, is the branch of medicine that applies medical knowledge to legal questions. It bridges the gap between the clinic and the courtroom, between the human body and the law. Its scope is wide. It covers the examination of injuries, determination of cause and manner of death, identification of individuals, analysis of sexual assault evidence, toxicological investigations, and the medical legal certification of medical conditions. In Bangladesh and across South Asia, forensic medicine is a compulsory subject in the MBBS curriculum, specifically because doctors regularly become involved in medical legal cases. As a physician, you may be required to examine a patient whose injuries may be evidence in a criminal trial. You may be called to testify as an expert witness. Understanding forensic medicine is not only about passing your exam. It is about being ready when justice depends on your accuracy. The core link: forensic medicine and the legal system. The justice system operates on evidence. Courts cannot accept assumptions. They cannot convict on emotion. They need facts, provable, reproducible, scientifically sound facts. This is where forensic medicine enters with a unique authority. A forensic physician can translate the language of the human body into the language of the court. Consider the key moments where forensic medicine directly serves the legal process. First, at the scene of a suspicious death, the forensic doctor determines preliminary cause of death, time of death, and manner of injury. Second, during a post-mortem examination, detailed findings are documented that can establish whether a death was natural, accidental, suicidal, or homicidal. Third, in cases of assault, rape, or torture, the forensic physician's examination provides the physical evidence that may become the cornerstone of prosecution. Fourth, in court, the forensic expert appears as a witness, providing impartial scientific opinion that guides the judge or jury towards a fact-based verdict. At every step, the integrity of that science determines the integrity of the verdict. Key disciplines within forensic medicine. Forensic medicine is not a single technique. It's an ecosystem of specialized disciplines, each contributing a different type of scientific evidence to the justice process. Forensic pathology is the study of disease and injury to determine cause of death. It is the core of most death investigations. Forensic serology and DNA analysis examines blood, semen, saliva, and other biological fluids, providing identification evidence that is among the most powerful in modern courts. Forensic anthropology helps identify skeletal remains, age, sex, stature, and possible trauma. Clinical forensic medicine involves the examination of living individuals, victims of assault, sexual violence, or accidents, and documents injuries in medical legal reports. Forensic odontology uses dental records for identification and bite mark analysis. Each must apply rigorous scientific methodology. Any lapse, a contaminated sample, a misread result, can collapse an entire case. Scientific integrity, chain of custody, and evidence standards. Now we come to the heart of this discussion: scientific integrity in forensic practice. Scientific integrity in the forensic context means that evidence is collected, handled, analyzed, and reported according to strict, transparent, reproducible standards so that the findings can withstand scrutiny in a court of law. The most fundamental concept here is the chain of custody. This refers to the documented, unbroken sequence of possession and control of evidence from the moment it is collected at the scene to the moment it is presented in court. Every person who handles the evidence must be documented. Every transfer must be recorded. Any break in this chain creates a legal vulnerability. Defense lawyers can and will challenge evidence if chain of custody cannot be proven. Standardized collection protocols, using appropriate containers, preservatives, and sterile technique. Accredited laboratory analysis, using validated methods with proper controls and calibrated instruments. Objective documentation. Findings reported factually, without exaggeration or minimization to favor one party. Peer review readiness. The forensic expert must be able to defend their methodology and conclusions under cross-examination. The justice system trusts the forensic physician to be the guardian of the evidence. That trust is earned, and it can be broken by the quality of scientific practice. The forensic expert as an impartial witness in court. When a forensic physician enters a courtroom, they do so in a unique capacity. Unlike a witness to an event, they are called as an expert witness, a person recognized by the court as having specialized knowledge that the judge or jury does not possess. This role carries a profound ethical obligation: impartiality. The forensic expert's duty is not to the prosecution, it is not to the defense, it is exclusively to the court and to the truth. In practice, this means you present your findings, you explain the science, you acknowledge limitations and uncertainties, you do not speculate beyond your evidence, and you do not allow pressure from either side of the case to alter your professional opinion. This is easier to say than to do. Defense attorneys will challenge your methodology. Prosecutors may want you to overstate certainty. The media may sensationalize. Public opinion may create pressure. The forensic physician must remain a scientist first and last, because the moment scientific impartiality is compromised, the justice system loses its most reliable anchor in truth. In Bangladesh's legal framework, forensic experts provide opinion evidence under the Evidence Act. Courts weigh this evidence carefully, which is why the credibility of your report and your testimony is inseparable from the justice delivered. Challenges to scientific integrity in forensic practice. Despite its critical importance, forensic medicine faces real and persistent threats to scientific integrity, especially in developing country context, including Bangladesh. Let us examine the major challenges honestly. Evidence contamination, improper collection technique, inadequate storage, or laboratory cross-contamination can render evidence inadmissible or worse, misleading. Inadequate infrastructure. Many public hospitals lack properly equipped forensic laboratories, refrigerated morgues, or trained forensic technicians. This puts enormous pressure on individual clinicians who may not be forensic specialists. Expert bias. Conscious or unconscious bias towards the investigating authority, towards social assumptions about a victim or accused, can distort findings. This is perhaps the most dangerous threat because it is invisible. Delayed examinations. Time-sensitive evidence, decomposition, drug metabolism, wound evolution require timely examination. Systemic delays can cause critical evidence to degrade or disappear. National standardization. Without nationally enforced forensic protocols, there is variation in how medical legal reports are written, how autopsies are conducted, and how expert opinions are formulated, creating inconsistency that defense lawyers can exploit. Recognizing these challenges is not a reason for pessimism. It is a call to action for better training, better systems, better advocacy. And it starts with doctors like you understanding the standard to which forensic medicine must be held. Real-world impact. Cases where forensic medicine delivered justice. Let us bring this into the real world with a few illustrative examples. Case Type 1. death by poisoning. A patient is brought to the emergency department unconscious and later dies. The family insists it was a sudden illness. The forensic toxicology report, however, reveals elevated levels of organophosphate compounds in the blood and gastric contents, consistent with deliberate poisoning. That toxicological finding becomes the foundation of a murder charge. Without forensic chemistry, a homicide would have been recorded as natural death. Case Type 2: Sexual assault. In a case with no eyewitnesses, the forensic examination of the victim documents specific patterns of injury, location, direction, and nature of wounds that are inconsistent with the accused's version of events. The DNA profile from biological samples matches the accused. Two lines of forensic evidence working together establish guilt beyond reasonable doubt. Case Type 3: Exoneration. Perhaps the most powerful use of forensic medicine. A man wrongfully convicted is exonerated years later when post-conviction DNA testing proves the biological evidence at the crime scene could not have been his. Forensic science does not only convict the guilty, it protects the innocent. These are not abstract scenarios. These are the kinds of cases that forensic physicians in Bangladesh and around the world engage with every day. The science you learn in your MBBS curriculum is not theoretical. It is the infrastructure of justice.